In R on the application of Prestige Social Care Services Limited versus Secretary of State for the Home Department, the Administrative Court addressed whether a successful defendant in judicial review proceedings should receive reduced costs where it prevailed overall but failed on discrete legal grounds. The claimant challenged revocation of its sponsor license. Following a one-day hearing, His Honour Judge Tindal dismissed the claim, finding the revocation lawfully sustainable under Annex C2 of the Sponsor Guidance, breach of sponsor duties. Pursuant to Section 31, subsection 2A of the Senior Courts Act 1981, notwithstanding that the court found the defendant's reasoning under Annex C1, non-genuine vacancies, irrational. On costs, the court held the defendant was entitled to costs as the successful party under Rule 44.22a, but applied a 15% reduction to reflect its failure on the Annex C1 issue, recognising that most costs were common costs under Multiplex versus Cleveland Bridge. The court further rounded down the final figure to £18,000 from an original schedule of £21,712.70, noting that 6 hours preparation for a one-day defendant hearing was excessive. Payment was ordered within 3 months. Quote, "The defendant's delay in serving a costs statement was technical and had no impact at all, as I reserve judgment. Nevertheless, I shall take it into account under paragraph 9.6. More importantly, under Rule 44.2, 4 and 5, whilst the defendant was the successful party, it did not succeed on all issues. There should be some deduction by a proportion to reflect that the defendant did not succeed on all issues. Doing the best I can on a broad brush basis, I will make a proportional costs order, making a deduction of 15%.
For a detailed summary of this decision, visit tmclegal.co.uk.